something easy and not controversial, privacy.
Great.
This has historically been under the FTC's purview, privacy enforcement. So do you think that, I guess first, should it remain that way under the FTC? And either way, is new legislation needed?
Okay, let me do a little table setting, and then, having completely dodged the question, you can remind me what it was. So, first of all, the traditional opening I have to give is that my remarks are just my own, and they're not necessarily reflective of my fellow commissioners. In fact, they're often not reflective of my fellow commissioners or the agency as a whole. And it's worthy of note that this is like an ill-fated event. Commissioner Slaughter is sick today, which is terrible. Though we had planned to do this event last summer in Aspen, and once she and I were scheduled on the same flight, once the flight got moved the 5th time, we were like, forget it.
But you were already in Chicago, weren't you?
No, we were still in DC.
Oh, you were still in DC.
We were having it, and I was like, no, don't go to the airport.
Well, I feel less bad then.
Yeah, you should not feel bad. It was a lovely summer day. Okay, so privacy, where should it be, and do we need legislation? I think probably the logical way to do this is reverse. So first, do we need new legislation? And I guess my fundamental answer to that is this is a giant question that Congress now is asking, right? I don't think there has been this much talk about consumer privacy in my lifetime. Certainly privacy vis-a-vis the government has from time to time, and certainly following the Snowden leaks been a major headline issue. But consumer data privacy is something that is a live issue in Europe. It's a live issue in the States. I'll be meeting later today with representatives of a Latin American country. Countries all around the world are increasingly trying to grapple with whether we need and what kind of regulatory scheme we need for the endemic use of data in the economy, because data are everywhere. And obviously the story also is informed by some really signature events that have happened. The Cambridge Analytica thing seems to loom the largest, but there are a lot of events involving data. Security, but also privacy, as we understand it. So I think, ultimately that's Congress's call. To my mind, there are sort of two really important questions that Congress is answering. One is a question about tools, and that actually seems to be more of the debate than I would like to see, Congress spends a lot of time thinking about rulemaking authority, and they spend a lot of time thinking about liability and who's going to be in charge of assessing that liability. Is it going to be just a federal agency? Is it going to be the states? Is it going to be private rights of action? All of those are really interesting and can be very consequential questions. To me, they're ultimately secondary. The first question is, what kind of regulatory scheme do we want? And I think, while if you look at some of the draft legislation, we are now finally getting to a level of granularity, which I think is helpful. Too much of the public debate has been focused on issues that are ultimately secondary. With respect to should it be the FTC, I think this is absolutely a bipartisan consensus at the FTC. The answer to that seems to me to be a very clear yes, and there are a few reasons why. So the first reason is that we're already doing it. Obviously, we're not enforcing a law that is not yet on the books, but there are a lot of privacy laws that are on the books today, and we've used our residual Section 5 authority, that's for unfair and deceptive acts and practices, to get at privacy for decades. So you've got a stable of people at the agency who are thinking about how privacy works. They're thinking about business practices. They're understanding how courts think about these issues. Seems to me a very natural place to put it. There are also some other structural features of the agency that I think commend it as above, say, a CFPB for privacy, which I think is a bad idea. The first is that the agency also does other things, and I think that can add important perspective to privacy. So one other thing that we do, of course, is competition. And I think having people who think about competition, who are the final decision makers, that is the people at the commission level, thinking about both, and I think, I've spoken about this recently, there can be some tension between the two. That's helpful. I think it's also helpful, we've got an important staff of economists who are trained to think about consumer harm with practices across the economy. We've got the experience on the consumer protection side of dealing with unfairness doctrine, right? So that's a pretty broad word that Congress actually had to cabin in the 90s after the agency in the 80s said we're not going to go too far with this, with its unfairness policy statement. But the whole concept was you'd be able to spot new things and see what effect they were having on consumers and whether they produced benefits and what costs they gave us. And I think all of that institutional knowledge and all of that institutional process would be really helpful in enforcing privacy law in a way that was protective of whatever rights Congress chose to create, but also mindful of the incredible growth that is predicated on the use of data in the economy.
So there's a lot in there.
Sorry.
Let me ask a couple of questions, follow-ups on that. So given all of the resources available to the FTC on privacy now and its actions enforcing privacy rules, what explains all of the sort of almost bipartisan, the generally bipartisan push for more privacy rules? I mean, do you think that the FTC has not been doing something? Are people sort of, I guess I don't really want to use the word, but overreacting to certain big events? Have things changed that mean the FTC should be doing more? Do people not know what the FTC is doing? What explains it?
I think there might be a little of a last thing, although some of our actions lately have made more headlines, I think, than in the past. Although it's worthy of note, there's some important privacy cases that haven't made headlines. So my sort of favorite recent one is the X case. This is a case involving a stalking app. That's a really important, concrete consumer harm issue that affects a smaller group of people, but affects them very, very negatively. Whatever negative or dignitary harm you experience from a cookie dropping on you, someone being stalked against their will is a real problem. And I think it's important to keep in mind that it isn't just Facebook and it isn't just YouTube. There's a lot going on in the privacy space. I mean, frankly, the case we brought in bringing TikTok under order did not get a lot of attention when we did that. TikTok now looms much larger in the popular imagination, and that wasn't that long ago. I'm very glad that company is under order. I think that's a good thing for America. So yeah, there is some lack of attention, but I think fundamentally, there are a number of factors that people are responding to. I'm not going to characterize whether they're reacting or overreacting. I mean, the nature of privacy is people have oftentimes opposing, but sometimes at least fundamentally different views of what the harm is. It seems to me that, data are being used everywhere in the economy. That is a trend that is only going to continue, right? With IoT and the ability to use machine learning to make use of all this data that we're collecting, that is a trend that is on the up and up, and I just don't see it. You'd have to be like a real dyed-in-the-wool Luddite, or someone who thinks we can recreate like the samurai giving up the gun in Japan to think we can really roll back that clock. So it's a thing that we have. And with it, I think there is increasing discussion of and awareness of some of the concerns that can raise. People can differ on the substance of some of those concerns, but the New York Times has its privacy project. It was a pull-out section, I think, 2 weeks ago in the New York Times, but it's been online for a while. So it's not at all surprising to me that where you see an asset class being used this much in the economy and you see its applications everywhere, it's creating a lot of value, to be sure, but it's not crazy that it's also creating some concern. I think that's part of what's motivating Congress. I think another thing that is motivating Congress, especially, I would argue, kind of on my side, on the Republican side, is that you are beginning to see a proliferation of state laws. And I think there's a lot of concern in the business community that those laws could be problematic, and also whatever the particular laws, that having multiple laws could be problematic. That's a view I share. But certainly that's a reason you would need a federal solution, because without a federal solution, you're just going to sort of have a patchwork.
So let me ask a couple questions about that. You alluded to the fact that the FTC also deals with competition as an asset to its dealing with privacy. So that relates to the speech you gave last week, where you talked about the relationship between privacy and antitrust. And correct me if I get this wrong, but I think you said that privacy and merger law shouldn't be combined or conflated, but that privacy is not irrelevant to antitrust or to competition law. Could you explain that a little more?
Yeah, and let me give a little context
Sure.
because I think that's helpful. So this is not a new narrative. Pamela Jones Harbor, who was at my agency years ago, used to talk about it. But it is increasingly prevalent narrative that we hear that we should treat privacy specially as like a goal for antitrust, that we should merge the two or converge the two. There was a whole conference on this in Europe last year. And you had senior EC officials talking about this. To some extent, or to a large extent, this is what we see in the Bundeskartellamt, the Federal Cartel Office in Germany, their case against Facebook. I find that to be, generally speaking, a bad idea, just because I view the two as different and using different tools to vindicate different values. I don't think privacy is irrelevant. I think people would generally agree that to the extent it's an aspect of quality on which firms are competing, that it can be relevant to antitrust law. That's something you've heard right and left. The Assistant Attorney General has talked about this. But one of the things I also said in the speech is, while that may be true, it's something about which we need to be careful. And the reason I think we need to be careful is that privacy is not, it's not like, say, for instance, price, where everybody wants lower prices. One person's experience with a given privacy harm may be very different from another person who may not even experience it as a harm. So like my father, just pick on him, he loves targeted advertising. He does. To him, it's very useful when he's seeing the ads pop up that they're things that he cares about and wants
I've
to
blocked
shop.
all of my friends on Facebook. I only look at the clickbait and the ads.
Scott. But that's not true for everybody, right? Other people find it creepy. I gave an example in testimony last year about like, you walk by a Starbucks and there's a pop-up ad for a coupon for a latte. So that could be really useful and convenient, or it could be creepy, right? You're not even in the store and they're pushing an ad at you. So where people have different tastes, and where I think there's actually a fair amount of agreement, market forces may not be doing all the work or not to reveal preferences, the project of looking at it as an aspect of quality is going to be a bit more complicated. James Cooper at George Mason has this paper on this where he talks about, he likens this question to trying to find antitrust harm in the decision of a restaurant to move from, like beans to corn, right? Is that a negative move? Is it a positive move? It may depend on the user, and that just complicates the analysis.
So firms compete in many areas. Privacy might be one of them, except that people's preferences for privacy differ, so it's hard to know what is
It may be. It's going to depend on the context, right? But if it's really a differentiated product, right? Some people have different desires, then that's a different thing from saying it's a reflection of market power.
Okay. Now, there was a report in the Wall Street Journal, I guess it was posted last night, so it's in today's journal, about the White House coordinating some efforts to create an alternative to Huawei. Now, this is just a report, there's very little detail, but it raises this question of firms or groups that want to sort of, that want exceptions to antitrust rules. One of the concerns raised with this idea was possible antitrust concerns. And obviously we don't know any of the details about this beyond a few sentences in the Wall Street Journal. But what do you think about some of these efforts to create antitrust exemptions, like there's a proposal for the news industry, for example?
So I can't speak to the report, I haven't read. What I will say is that, and I've seen other proposals too, it's very easy and very tempting to say that person is suffering in the market, let's find some sort of special legal protection from them. One of the benefits of antitrust is that it's a law of general application. And one of the things that antitrust has done that has been really positive is moved from a place of protecting particular market participants vis-a-vis others based on some squishy notion of like what fairness ought to dictate. And I don't know that legislating that is any better. And I worry that it's, you can have public choice problems where you get an industry and they get protection and then they exploit that protection and consumers suffer. And that's something I think we don't want. So as a general matter, I don't like special exceptions. I think it will be easy in the development of any market over time, from time to spot losers. And sometimes those losers are very sympathetic. That's not unreasonable, and sometimes we make laws to protect them. I mean, labor, right, has an exception for antitrust. That's been on the books for a very long time. Some sports leagues have an exception to antitrust. That's a little bit different. My general view is that creating special exceptions is not the right way to go about things.
The new vertical merger, draft vertical merger guidelines, what do you think is actually new in these? I mean, if you compare them to the existing non-horizontal merger guidelines, they look pretty similar. The 20% thresholds are a little, it's a little more clearly defined. But what do you think is the biggest change from the existing rules? I mean, and I know these aren't finalized, but.
So let me start with a caveat and then a plea. The caveat is that we are in the process of collecting information on the proposed guidelines that have been put out jointly with the Department of Justice, and to the extent anyone listening or anybody watching or anybody reading is interested in, the comment period is open. We very much take these inputs as part of our process. I think the big thing that the draft proposal gets to is it reflects agency practice. The previous non-horizontal guidelines are from 1984. No one thinks they're good anymore. My view of what we heard in our hearings, and we're going to do yet another workshop on the draft that's out, but on the hearings that we were having in 2018 and 2019 on this issue, no one thought the old ones were kind of good law or good practice. And I think the present draft really reflects how the agencies are doing this. And I think there's a lot of value to practitioners, to the market, in understanding what agencies are doing.
So what has been updated? I mean, what's in it now that was not reflected earlier in the guidelines? Or were just the previous guidelines just kind of ignored? I think that's the wrong word, because they couldn't. But what's really the new thing here that's updated?
I mean, I think it really lays out the frameworks for, specifically in the context of vertical transactions, and this is an important distinction. The draft makes explicit reference to use of analysis from the horizontal guidelines on issues like entry, and market definition, and so on and so forth. But in the context of vertical mergers, there's a series of concerns that may arise depending on the facts of the market, like foreclosure. And this sort of goes through how we look at issues like that.
So one of the things that there seems to be some disagreement about is whether how to exactly consider these thresholds, the 20% above, below, and acquiring market related products. Should these be thought of as analogous to the HHI thresholds in the horizontal merger guidelines, where they don't, say this should not be allowed, this should be allowed, but sort of saying this is something we should look at, this is less likely to be looked at. I mean, there seems to be a question. Some people call the below 20% a safe harbor, but that phrase is not in there.
Yeah, it doesn't say safe harbor.
Yeah,
I mean,
okay.
I think it's a less likely, more likely kind of thing, and then the language makes very clear, depending on the facts. This may or may not be.
One thing it does not do is say that vertical mergers should not be presumed lawful, which Commissioner Slaughter said in her dissent that she thought they should. And I don't
think she said they should be presumed lawful.
No, she said that the new guidelines should, and maybe I'm wrong, and so I don't want to put words in her mouth if I'm quoting her wrongly, that it was important that new guidelines establish that vertical mergers not be presumed lawful.
Okay.
Do you think that's right?
Let me say two things. The draft that's out there doesn't provide for a presumption
Right.
one way or the other. And the presumptions in horizontal practice and in law, right, in the way courts treat it, do a lot of work, right? Because once you shift the presumption to the other side, then it's on the other side to prove out of that presumption with whatever evidence they have with respect to efficiencies and the like. You want presumptions in general to reflect reality, to reflect what we see in the market, what our experience is in enforcement. Otherwise, they're not well grounded. I don't see that presumption in there. It'll be interesting to see what we hear from commentary with respect to that issue. I think, though, what my understanding of the economic learning shows is, and this is actually also true for horizontals, most vertical mergers are either competitively neutral or pro-competitive. And vertical mergers tend to be less problematic in and of themselves than horizontal mergers, right? Just because you're not taking out a competitor or however the market looks or whatever the underlying facts are, and the fact that there are very natural efficiencies that attend most integrations above and below on the supply chain, there's sort of less to fear in general.
Okay. Let me ask one more thing, and then we'll go to questions. I want to make sure we have a mic. Do we have a mic for questions? Well, why don't you find one?
Or you can just say them.
Yes, right. But, okay. How should we think about acquisitions by big firms, right? This is another big question.
Hard.
Yes, right, but I mean, it's either the key way entrepreneurs exit and an incentive for them to enter the market, or it's a way that big firms keep competitors from growing, or both. How do we, I mean, that's a big issue right now. How do we deal with it?
So, I mean, you're right, this is a big issue. It's something that I think everybody is thinking a lot about. It's something we talked about at our hearings. It's very much at issue in a case we just brought. Illumina, which is a gene sequencing company, proposed to buy PacBio. And we were concerned that that was like a nascent competitor. And so we brought a case. Let me say two things. I think that this is, first of all, it's not an issue limited to tech.
No, not
at all. There's this very famous academic paper by Cunningham and Ederer, I think. If I got that wrong, I apologize. Called Killer Acquisitions. And the phrase you hear about talked in terms of tech, it's not about tech. It's about pharmaceuticals. So I think it's an issue of increased focus. We've brought a case about it. But you're absolutely right, Scott, that there is a terrific M&A is not in the main negative. Firms can grow through M&A, and investors can exit through M&A. And that's very important if you think about the world of those who invest in innovation, venture capitalists. Not every company is going to be a unicorn, and not every firm is going to have a unicorn in their portfolio. Which means, if you're going to make the economics of venture investing work, which is to say, most companies fail. Right? That's a thing that happens in the world. Having exit through M&A is important for investors too, and for spurring future innovation. And I think in thinking about this issue, people are very concerned, but you don't want to correct in a way that makes it much, much harder to exit, and that deters, right, the willingness of investors to invest in innovative products across the economy. That's a really important driver for economic growth, not to mention consumer value.
Questions? Laura?
So I have two. The one I came in with is, you find Facebook $5 billion, and then we're talking about breaking it up. So I'm interested in philosophical on you thinking about, what do you think breaking up these big company solves versus fines? And what if none of it works? Like, let's say you undo Instagram, that's okay, they build another one and they just put the new public standalone one away, and you fine them 20 billion, they don't change behavior. What do you do now? Because these companies are big in their own right and they're not asking your permission to do anything.
Right. So to me, the first question is, what is the problem that we're trying to solve? One of the things that I find frustrating about the talk of breakup is it's not always clearly tethered to an idea of how the breakup will solve the market problem that the government intervention is aimed at. So, in the speech I gave last week, I was talking about privacy. So if you broke up Facebook and Instagram, maybe they would compete on privacy. I don't know. That's possible. Maybe they wouldn't. Maybe they would compete to extract data from users and monetize it. That's a lot of faith is placed in just breaking up companies, and I don't think that's the right way to think about the issue. I think you have to think about what is the market problem that you're solving. And by the way, large companies can present more than one market problem. You could have a monopolist that is also creating an environmental problem. We wouldn't solve the environmental problem the same way we'd solve the monopoly problem if the monopoly were illegal, because monopoly in and of itself is not illegal. So I think that a lot of the conversation has to do, or is too divorced from what the harm we're trying to solve, and then how the solution, right, gets at the harm. In terms of breaking up companies, another issue we have to deal with is our level of confidence that a remedy would work. I mean, your hypothetical is the remedy doesn't work, right? And that's something that we have seen. Remedies are not perfect. This isn't, it's more art than science. There have been, AT&T is a very famously successful breakup of a company that achieved, I think, really pro-competitive results. The most famous breakup in the world had mixed results. That's Standard Oil. The price of oil went up, and that was like the first thing the FTC was asked to do. Why is the price of oil going up? So I think you have to start the conversation with what is the problem we're solving, and aim the remedy, whether it's legislative or antitrust or what have you, at that, and have a good idea of how your remedy addresses the problem. So I missed the other question. You had another question.
Well, I just wonder if that doesn't work. Like, if you can't find them enough to change their behavior, and you can break them apart or you don't because it doesn't, like, what then?
I mean, again, this is presuming we are agreeing on is actually, I think, when you're talking about some of the large tech firms, people have a lot of different concerns, right? I think it is naive to assume that any one solution solves all the concerns. I suppose legislation, right? But if you have a problem that neither law enforcement, that law enforcement cannot solve, and I'm not conceding, but if you have a problem that law enforcement cannot solve, and that with intervention from antitrust, that the market alone is not solving, and that with intervention from antitrust the market will not solve, I suppose that's where legislation becomes most appropriate.
And then my question from what you said was, one of the things was there's synergies in you guys doing antitrust and privacy. I'm interested in how does that information flow occur? Like, if usually in big institutions things are siloed, so somebody's doing work over here and somebody's doing work over here, you get monthly meetings. How does that information cross across silos?
On some level, depending on the case, you might have a formal, for whatever reason, there are equities of, let's say, the Bureau of Consumer Protection and equities of the Bureau of Competition, and they might both intervene. You have certain offices, the Office of Policy Planning, we're talking about our agency, and the commissioners who do both, and so they're just people who are kind of mindful of those things, for lack of a better word.
Yeah.
Hi, Brian Tracy with the Wall Street Journal. I wanted to ask you about facial recognition.
Mm-hmm.
We've seen bipartisan concern at the local level, state level, congressional hearings about this technology being used more often, public and private sector uses. What, if any, role is there for the FTC on addressing some of the concerns that are out there?
Well, one of the things about our authority is that it's right, by design. So unfairness of those have separate analyses. And there's no reason they can't read on facial recognition technology like they would read on any number of other technologies. My sense of the debate with respect to facial recognition is that there are a series of concerns that aren't specific to our authority, right? There are concerns having to do with, let's say, law enforcement access to data or national security access to data that are not really what we are doing. But to the extent facial recognition implicates our jurisdiction, there's certainly no bar from us looking at it. I will also note this. Part of the reason we're seeing, and like with privacy generally, more facial recognition concern is that we're adopting more facial recognition technologies. And it's important in this debate to recognize the work that those technologies are doing. It kind of gets back to this issue with respect to privacy of different people experiencing things differently. One person might find technology at the airport or invasive, and others might appreciate the increased speed or public safety that comes with it. Facial recognition technology is spreading because it has tremendous value in the market, including to law enforcement and national security. So there are really important equities on both sides of the issue.
Here, and then go ahead.
Morning, David Happ with the Deal. Commissioner, why do you think that the FTC lost its challenge of the Ivanov PeroxyChem transaction, and what does this mean for your ability to challenge horizontal mergers going forward?
That's a good question. The status of the case is that it remains in what is called Part 3, which is so there was both a PI, a preliminary injunction motion filed in federal court, and then there is, the case is also filed in our court. And because we sit above our court and it's still sub judice, I have to avoid commenting. What I can say generally is that we don't always win our cases. Judges can look at a market and just not by our market definition, not by the way we treated entry. I mean, there are any number of factual patterns, not by our story of how the negotiating leverage is going to change and going to hurt consumers. Again, I'm not speaking specifically to that case. That is something that all antitrust agencies grapple with. That's the first thing. The second thing is this. We spend a lot of time in the public talking broadly about antitrust. You'll see a lot of op-eds written that call for fundamental change and focus on one or two anecdotes. What I do every day, and what we grapple with every day, is the particular facts of the market and the transaction at which we're looking, or the conduct at which we're looking, if it's a conduct case. And generalized statements cannot always be drawn. Oftentimes, we are really focused on the facts, and judges will very much focus on the facts. So there will be times where you'll get a decision and it won't necessarily radically change the world. Because it's not my case, I can probably say that. I don't know that the DC Circuit's decision in the AT&T case radically changed. People can differ about the merits, but both the district court actually and the appellate court largely focused. And again, people can differ on them. I don't know that it was, to some extent, it was a disappointment to antitrust practitioners. We would love a lot of new case law, but many cases are really like the general principles are understood, and then it's the facts where the debate is had.
Could I just follow up to ask, is this more of an issue of the selection of this transaction to block, or of the legal case that you tried to build to block it?
Again, so it's still in Part 3. I don't want to speak to that case in particular.
Yeah.
Hi, Nadira Bose with Reuters. Good morning.
Good morning.
Thank you for taking my question. So over at the DOJ, just a couple of months ago, Mr. Doheny said that thinking of privacy concerns, it would be a grave mistake to think that privacy concerns do not play a big role in antitrust analysis. you're saying that treating privacy as a goal of antitrust, we need to be careful. So I kind of want to better understand, especially with regard to the tech companies that you're looking at, how big a role are privacy concerns sort of playing as you sort of, investigate them or you look at them closely?
So I don't want to speak to anything we may or may not be investigating. I mean, one big tech company has publicly confirmed that we're conducting an investigation, and beyond just confirming that, there's nothing I can say. That's thing number one. What I'm saying is, and I think there's a fair amount of consensus on this, we can look at privacy as a kind of quality, right? And where firms are competing over privacy, the example I give in my speech is like, if Google bought DuckDuckGo, right, which is a company that very much makes a point of competing on privacy, that's something I think we're going to be looking at. I don't know that they're planning to, but that would take a close look. But privacy is not like price, where it's obvious what is better and what is worse. And where that is true, where it is not obvious what is better and what is worse, distinguishing a differentiated product from an exercise of market power, knowing what is really evidence of harm to competition, a competitive harm versus just people disagree, is a harder thing to do. And my prudential worry about this is what I don't want us doing is sort of substituting our privacy tastes for what the market will yield. That I think is a dangerous game, and I don't want to be playing that game.
I want to go back to the vertical, I'm not a reporter, I'm just an
I know.
antitrust lawyer. So I'd like to go back to the vertical merger guidelines, which when they were originally put out, it was a relatively short comment period. And what I heard through the grapevine was that they were very carefully and painstakingly negotiated, and there might not be a lot of room to change because you had to get so many different DOJ and the various commissioners all on board. And then we saw just recently that you extended the comment period and are now going to be hosting that workshop. So that seemed to suggest to me that there is really more of an opening, that you are, I don't know if that was a reaction to what you heard in, the response you got to the guideline, or whether that was always the plan, or what does that say about the agency's willingness to get in there and maybe, think a little bit more about some of these issues?
So again, these are out for comment. I'm not prejudging. Certainly the extension of the deadline and the opening of the workshop, I think to me reflects more than anything public interest, right? People are interested in the topic. They wanted more time. They want to see more of an airing, and I think those are good things.
Hi, Carl Herkenroder with Com Daily. I'm curious, do you have any issue with Facebook repeatedly buying up and growing the next large social network? The financials are out, and it looks like Instagram could, at some point, overtake Facebook just based on sales.
So that's part of what Scott and I were discussing before. We are always interested with any firm, especially firms that can be characterized as dominant in any given market, using M&A in a way that is anti-competitive to keep competition from happening. Every fact of every case differs. I'm not going to prejudge any market, but that was the Illumina PacBio complaint. That's a nascent competitor coming up. So that is definitely something at which we're looking. Generally.
Following up on that, there were these hearings in Colorado recently, and lots of smallish firms complaining about the bigger firms, like Tile complaining about Apple, firms complaining about Amazon. Is there merit in their complaints, do you think? Should we be doing anything about it? Or is this, another example where we should just focus strictly on consumer welfare?
I mean, I don't want to speak generally to the specific complaints of specific firms. Look, part of what we do on the competition side is we hear from people who are aggrieved in the market. Sometimes they're aggrieved because they're being outcompeted, but sometimes there are legitimate issues. Right? When we bring cases, it's often based on evidence of talking to people participating in the market. It's just going to depend on the facts of the given case.
Yeah. Rebecca.
Rebecca Argas, Comcast NBC. A lot of the issues that you've been talking about today are being discussed in Europe at the commission level, at the member state level, Australia and so forth. Could you just give your thoughts on the value of the different jurisdictions harmonizing their approach versus tacking off in different directions?
Someone called this the splinter net to me last week. Yeah, my fundamental view is that harmony is good, at least within the bounds of those nation states that have more or less agreement on basic values, which is to say I can understand if we're concerned about free data flows with a China or a North Korea. I'm not grouping the two, they're different cases, but as a general matter, my view is that there are a lot of gains from trade, including trade in data, between the US and Europe. I don't think it is in the interests of Americans or in the interests of Europeans, frankly, for us to kind of have little cloistered areas and we don't share data with each other. I think we benefit from trading with them and they benefit from trading with us.
And I was thinking even more broad than data flow is competition theory, for example. I mean, just the discussion of online harms, of how we're going to analyze or revise, if at all, how we approach antitrust law.
I don't know that it warrants a dramatically different approach, although I want to address kind of a somewhat hot topic at the end, and if I don't, remind me to come back to it. But to the extent, and look, we are having like a giant national democratic conversation about the impact of trade generally and how disruptive it can be. From a competition perspective, though, which is my focus, it is, by the way, amusing to go abroad and people are like, oh, you do trade, tariffs, and I'm like, I don't do trade. The more globalized the market is, and the more the internet, in particular, provides an ability of a seller in Mozambique to hit a buyer in Michigan, the more we have to take that into account in our analysis of the market, right? And so there are a lot of barriers to entry that have been eliminated altogether, or at the very least reduced by the sort of free commerce that the internet allows. And that can be really good for competition. It may impact how we deal with entry, let's say. But there are a lot of different issues on which it bears. The one thing I wanted to single out, there was a bit of a fracas last year in Europe. The Directorate General of Competition, Commissioner Vestager and her folks, challenged a merger. And some of the nation states, these were big industrial companies, and some of the nation states where those were sort of kind of national champions were pretty aggrieved by that. And there was kind of a legislative push, and I think I saw it pop up again, although I might have been misreading the headline. There is this thorny question that comes up of like, what do we do as the US when other countries are specially treating their own companies? Right? They are being protectionist. They are providing a safe space for their firms, to like grow without competition. That's a hard question. My gut is that we have won traditionally not by doing that where others do that, but rather by competing vigorously. We have sufficiently large market economy to allow for that competition, and we continue to have firms that are leaders. But that is an issue with globalization, with the growth of some firms that I think will continue. That'll be a perennial.
Thank you.
Sure.
This might be a little bit rhetorical. Sorry. Hold on one second. Let me just follow up on Rebecca.
I tried.
But no, the next thing. So, how do we think strategically about our relationship with the EU? So, when we coordinate, that might require being more aggressive than we might like, and if we don't coordinate, that leaves them to be even more aggressive. I mean, that's a bit rhetorical and hypothetical, but I mean, how do you think strategically about this?
I do get a little bit concerned where I sense that let me say the following. A person I will not name who was an executive of a European company came up to me at an event and he said, why do you guys beat up on your companies? No, I don't think that's the right approach. Right, as I just said, I think we traditionally win by competing and enforcing competition law. I do worry that US firms sometimes are targeted more because they're US and less because they're firms. And I do find unsettling the value judgment of our law enforcement and national security apparatus without any correlative discussion of what European national security and law enforcement privacy practices are. I don't think it's fair to say you guys are inadequate without any recognition of what we guys are doing. So I would like to see, and I think there's been some of that, the administration's been pretty good about elevating that issue. This started at the end of the last administration, but I think this administration has been really forceful about it, which is good. They have privacy-related practices too, and I do think that needs to be part of that discussion. Neil.
Neil Chilson, Charles Cook Institute. We talked about cases that go under the radar, and one that I was particularly interested in was the BMS Celgene divestment and merger approval, which had 4 very enthusiastic statements, and that show quite different regulatory or enforcement approaches. I just wondered what lessons would you want people to take from those 4 statements about enforcement approaches of the current FTC or perhaps future differently constituted FTC?
So I will stick to my statement and what I want people to take from that. My statement was, I think it's fair to say, a pretty forceful pushback against 2 of my colleagues. And the criticism that I leveled was that I felt that their dissents did not explain why and on what legal basis and based on what set of facts they would have litigated after the remedy. There was no quibble that the remedy addressed all the competitive concerns that were found. And I think in a rule of law country, if you don't have facts and you don't have law, you don't have anything. The way our regime works, and I do think it's the right regime, the government has affirmatively to challenge a merger. At the end of the day, we don't get to say you don't merge and then there's no challenge to that. And presuming people are complying with the law or making changes that bring them into compliance with the law, I think judges don't take lightly to government not having a theory why something is bad. I felt very passionately about that. That's why I wrote it in the way that I did. I just don't think it was fair to look at a situation and fail to talk about the facts of that case or about law.
Alex Sim, and I'm with Beta Partners. We just do research. But I have a question. You talked about nascent competition. Do you think that harming innovation is sufficient reason to bring an effort to block a transaction?
Standing alone, look, innovation harms are something at which antitrust looks. The set of facts that are innovation and nothing else, I don't have a hypothetical in my mind, but definitely when we talk about what antitrust aims at, you'll see, the Times will print this, antitrust is just about short-term price effects. It's not. No one has ever said that. It's no one I know. And certainly innovation is on the list with quality, with privacy, right, of kinds of quality harms that we're concerned about.
Okay, well, so you said that people were talking too much about tools, that you didn't think that was a particularly...
In privacy.
In privacy, right, that's true, okay, because I was going to ask you about tools, but not privacy. So what do you think should be the role of states relative to the federal government in antitrust or privacy, for example? How should attorneys general interact with the federal authorities, whether it's DOJ or FTC?
I mean, I think we should both interact with each other well. Look, they have
Okay.
they have jurisdiction. They have legal authority. In many cases, they can be really important additives to what we're doing. We're not going to be able to bring every case. And there are certain cases, hospital cases sort of famously for this, that may present local equities where the big scary federal government coming in would really be helped by having the state AG there with us. we sort of have 52 antitrust authorities in the United States, and sometimes if people draw different conclusions, there can be friction. But there are also really good opportunities, I think, for parties to work together. With respect to privacy, basically the same thing. We worked very well in our YouTube case, right? That was a case brought jointly with the Attorney General of the State of New York, Tish James. I do think, though, that with respect to legislation, where you have a market that really does not have anything to do with state lines, very much interstate commerce in the way that the founders understood it, even if they didn't have the internet in mind, I do think for purposes of growth, and also really importantly for purposes of consumer understanding, I'll come back to that, I do think having one rule is the right way to do it. So let me just dwell on consumer understanding, because I think this gets lost too much in the debate. To me, and others will differ, but to me, a large portion of the privacy debate has to do with consumer understanding. People have a sense that something is going on, or they read something in the newspaper, and they're upset by it, or they're surprised by it. And there are a lot of things going on that people just aren't generally aware of. Now, not every consumer, in fact, almost no consumer, is going to know everything that is going on. And many consumers may not care to learn, and that's fine. But I do think one of the things we have is there are things going on in the market where we just have sort of a deficit of understanding. To me, having a bunch of different state laws with different standards exacerbates that problem. Knowing what the rule is, the UCC, there are lots of examples of this, helps add to consumer understanding. And that, to me, being one of the problems, I think that's an example of a tool that can be fashioned in such a way that actually helps or hurts, depending on how you fashion it, address one of the substantive underlying issues. Okay. Oh, yeah, there, in the back.
Hi, I'm Daniel from Georgetown University. I wanted to ask if, when it comes to AI, if you think there's a trade-off between privacy, meaning transparency and explainability, versus performance, accuracy and efficiency. So the more, my train of thought is the more data an AI system has, the better the performance. And how does the privacy regulations connect with?
Right, I think that's a great question. So I think your intuition is right? To the extent you're training the AI on data, the more data you have, provided it's accurate, right? Inaccurate data is actually not that helpful because it will send, force the algorithm, or the algorithm will learn the wrong things, what have you. One of the things we really need to take into account when we think about how best to regulate the trade of data is that part of the reason we're seeing such an explosion of AI is that we have all the data. The more you choke that off, the less good the AI may be. And that's just a trade-off we have to recognize. I mean, all legislation comes with trade-offs. Whenever anyone tells you this is an unalloyed good, I think they're selling you a bill of goods.
What happens with privacy and competition have opposite effects. So like take TikTok, for example. People have lots of privacy concerns about TikTok, but it's become a huge competitor to Facebook. We want competitors to Facebook and Instagram. But people also have major privacy concerns about how do you deal with those two things.
Yeah, I mean, I think that's a nuance we absolutely need to recognize. To the extent that's how the competition is looking, I think it's fair to ask, is that what you meant when you were glorifying how the competition would look? And I think this is the thing with privacy that makes it more difficult as a competition issue, that the market doesn't always bear out our idealized version of how the world ought to look. And where preferences aren't getting reflected, we could have a good, healthy, competitive state, and some people may still be upset with that. I don't think it's fair to say, back to your question earlier, this remedy is going to solve all our problems. I think that is just wrong. I don't know why that would be true, and anyone who makes that claim, I really want to see why you think that's true. So. Okay. It's 11 o'clock, so thank you very much. We really appreciate your time. Thanks for coming.
Thanks, everybody.